afternoon, everyone, and welcome to today's webinar. Today's topic is the law and COVID-19, a small business's Q&A on matters of employment, finance, and real estate. Before we get started, I'd like to take a moment to go over a few housekeeping items. My name is Allison, and I'm the webinar organizer for today. We want to make sure today's presentation is extremely valuable for you, so we ask that you submit all questions by clicking on the question button in the control panel and typing your question there. Now, please join me in welcoming McCarthy, Lebit, Crystal, and Liffman's David Lum, a business and commercial real estate attorney with more than 25 years of experience. He's rated a best lawyer by the legal community in Cleveland. Without further ado, here is David.
Thank you, Allison. Appreciate being here, and we want to thank you and Cose for having us here for this webinar today. We at McCarthy, Lebit, Crystal, and Liffman are thrilled with our new sponsorship and partnership with Cose and Greater Cleveland Partnership. You know, Cose is a great organization for small businesses, and as a small business ourselves, we think McCarthy Lebit fits right in with the Cose model. As you'll see from our logo, we have a tagline up there that says expect more, get more, and that's the kind of value we like to bring to our clients, and hopefully that we can bring the value to Cose and its membership starting today with this webinar. We also have an exclusive offer for Cose members that we will talk about at the end of the webinar. Now, the agenda for today's webinar is I will give a little introduction about the firm and tell you a little bit about us. I want to introduce our other panelists. Then we'll have a presentation of a series of frequently asked questions related to COVID-19 on the areas of employment law issues, banking and finance, as well as real estate. After that, we'll take some questions and answers from the audience as they come in, they typed in. Then we'll go over sort of our exclusive offer for Cose members. Now, a little bit about McCarthy, Lebit, Crystal, Liffman. The firm is 60 years old or thereabouts. We're located in downtown Cleveland. Approximately 40 lawyers and 70 employees in total, and we have a wide range of areas of expertise. Our practices revolve around two areas: businesses and people. We have the full range of business practices, which start with alternative dispute resolution, banking and finance, business and corporate, litigation, real estate and construction, employment, insurance, defense, intellectual property, M&A, and taxation. Likewise, we have a part of our firm dedicated to sort of personal practices, which include things also ADR, criminal defense, employment, family law, investor claims, litigation, personal injury, taxation, trusts, and estate planning. We like to think that we have a large firm expertise and resources and small firm accessibility and responsiveness. So with that, I'd like to introduce our other panelists today. We have Anne-Marie Ahern here. She's a partner at our firm and the employment practice lead. Anne-Marie's a stalwart at the firm, and Best Lawyers announced her as the 2020 Attorney of the Year in Employment Law. So we're happy to have Anne-Marie talk about employment. Next up, after employment, will be Mike Makofsky. He's a partner in the firm and the banking and finance practice chair lead with over 20 years of experience. He'll be talking about banking and finance issues of COVID. And finally, I'll be answering some questions on real estate. So with that, I'd like to get right to the employment law questions, introduce Anne-Marie, and we can flip the slide to the next. So we've come up with a few frequently asked questions, and we want to go over them. So I'll pose the first one to Anne-Marie. Anne-Marie, what does a business need to do if they have an employee who is tested positive for COVID-19?
Thanks, David, and I just want to thank our audience members for participating. These are very interesting times that we find ourselves in, and I think that I have remarked a lot recently that it's a very hard time to be an employer for a lot of reasons, and I think if that is true, generally speaking, it's even harder to be a small employer right now. And we'll talk about some of the reasons why, but I have actually had more than one of my small business clients who has had employee who has tested positive for the COVID-19 virus. And we've really, like so many other situations right now, the response to that is kind of an unprecedented one. You know, when we have other workplace injuries or situations, most of us know exactly what to do and how to spring into action, but this situation is different, and there's no real definitive guidance for an employer and for small employers in particular on how to appropriately deal with these situations while also protecting the business and the health and well-being of our other employees. So the preliminary, and I would say about this situation, as all of the situations that we're going to talk about today, these are very fact-specific situations, and the individual circumstances of your business, the kind of business it is, the duties and responsibilities of the employee, and the size of your business are going to, in large part, dictate the specifics of how you implement these instructions. So what I'm saying is kind of general, and if you find yourself in this situation, you want to make sure that you're looking at it on a very fact-intensive and practical way. But obviously, the first bit of advice is to immediately send the employee home. And that is true whether the person has tested positive or is just exhibiting symptoms. And for the next step, it's really important, and this should be done either over the phone or before the employee has been sent away from the workplace, to try to ascertain exactly who the employee has had contact with. So it's important to understand when the employee was first symptomatic, any type of symptom. And sometimes people don't realize that they're symptomatic until the symptoms start to accumulate. So for instance, if a person has felt tired for several days, but doesn't actually get any other symptoms for several days thereafter, you're going to want to go to when they first, in hindsight, realized that they were symptomatic. And you're going to look at how for the 14 days prior to the first day that they were symptomatic, and ask that employee to try to make a list of all of the people that they may have had contact with within 6 feet, and ask them to walk through their days and retrace their steps so that you can, to the best of your ability and the employee's ability, figure out who they may have had contact with that would have caused potential exposure. The next step is to notify those employees who have been potentially exposed of their potential exposure, and send them home, if at all possible, with instructions to contact their health care provider and follow CDC recommendations. It's really important that people are told that they should seek professional advice, and that the employer is not dictating the employee's next steps beyond those involved in the workplace. And then,
Emery, we had a quick question that came in. When you say who they had contact with, do you mean only at the workplace?
Yes, only at the workplace. And beyond the workplace, it can't hurt to advise the employee that they should conduct a similar exercise and make a similar list and share this information with people that they may have had exposure to in their personal life as well. I think that's a socially responsible thing to do, but probably beyond the scope of anything that you can enforce in the workplace.
Great, thank you.
No problem. So the employees, and as I was working through this exercise with one of my clients, I thought about it in terms of like concentric circles. So you have this employee in the middle of the circle, and then you have the people that they actually had contact with within 6 feet in the next circle, working your way outward. And then you have the rest of the employees of the company in the most outer ring circle. So if you think about that middle ring, the employees who were potentially exposed, they need a little more information than the general employee population of the company who has not had immediate contact with the infected employee. So it's important to notify those people of their potential exposure so that they can be hypervigilant in monitoring their own health, their own symptoms, and reaching out to their own healthcare provider. Next, we want to notify all other employees of the company that there has been an employee who's tested positive. And this is something that is really just the best practice. It's not required, but in terms of maintaining employee morale and having the employees feel that they work in an environment where their employer is truly concerned about their well-being, this is something I think, if we're honest, we would all want to know. If our employer had an employee who had tested positive, we would all want to know that. And we have to do this in a way that is mindful of the rights of the individual who is the infected employee. So to the extent possible, the employee who has become infected, their identity should be kept confidential. So the employees who have had immediate exposure, you might identify the department in which this person worked. You might identify when they may have last had contact, but it's important that you don't do anything to unnecessarily violate the privacy rights of the employee who is already going through a tremendous amount of distress, having been diagnosed with this disease. So the general employee population should be told that they should be hypervigilant about monitoring their symptoms, to continue to be sure to observe the CDC guidelines as well as all appropriate social distancing recommendations. And then finally, there's a very specific CDC guidelines as to cleaning recommendations for any facility that has had a positive case. Once that kind of initial response, like that, I would say that that's within the first 24 hours. Once you're beyond that, it's important to regroup and determine the next steps, which are going to depend in large part on those type of business you are, whether there are FMLA considerations, how serious the employee's case is, whether you can implement additional work from home, whether there's been any business interruption.
Great. I think that's great advice, Anne Marie. To move on to sort of our next question, say our running a business and our business is slowed down as a result of the COVID situation. We're considering letting people go. What are the things that those businesses should be considering?
So a lot of businesses obviously find themselves in this situation, and you need only look at the astronomical and record-breaking unemployment claims to know that this is a decision that a lot of companies have already been forced to make. But to the extent that businesses are considering new layoffs or other ways to conserve cash in the short term, it's really important to be deliberate about these decisions. And even though there's a tremendous sense of urgency that we're all operating under, it's really important that nothing be done in a knee-jerk fashion, because a lot of these decisions will have both from the standpoint of employee morale and planning for the future and strategic planning will have real and meaningful consequences beyond this pandemic, but also from a financial standpoint. And I know that, Mike, you are going to talk a little bit about this issue, but one of the primary things that every business who has applied for a loan and whose loan has been approved under the payroll protection portion of the CARES Act, it's really important that you understand that a layoff may have a effect on the forgivability of the loan that you've taken. And so it's really important that if you're going to implement a layoff, that you're doing so with full awareness of the impact that may have.
Anne-Marie, I think that's a great point. Just as an example, I checked in with a client of mine when the situation came up to see how they were doing, and they were getting ready to lay off about 40% of their workforce due to this problem, all of whom were very difficult to replace and expensive to replace employees. And I asked them if they had checked in and looked in at the payroll protection program, and they weren't aware of it. I made them aware of it, as well as the idea that if they eliminate employees, they may not get forgiveness on a loan, and it instantly changed their thought on it. It allowed them to keep their essential employees without having to lay them off. They've applied for the loan, hopefully going to get it, but because they didn't make a knee-jerk reaction, we were able to help them.
Right, and I mean, if you look at the entire purpose of the Payroll Protection Act, it is to give businesses the ability to maintain payroll during this crisis. So, that's something that I don't know that people are connecting all of the dots, because we're in this really unusual time and people are looking at their cash flow and have real legitimate concerns and think that the obvious answer is to reduce payroll. And it may not be something that's advisable. You may be essentially throwing away money if you were to do that, if you are a business who's been approved for this loan. Beyond that, if a decision is nonetheless made that a reduction in force needs to be implemented, it's really important to be strategic about how those decisions are made in this time. So, I think that what I'm seeing with a lot of businesses is that a lot of our clients have had really unprecedented years over the last several years in a healthy economy, in a low unemployment environment, and have had the ability to perhaps carry some employees that they may not be essential, and that probably, frankly, would not be employed in leaner times. And so as you're implementing a reduction in force that is COVID driven, it's important that you be mindful of the same considerations that you would be looking at in any other reduction in force environment, which is, what employees, as you emerge from this crisis and hopefully return to a healthy company and a thriving company, which employees do you want to come through with on the other side? Which employees are going to be the most likely to respond to and ask to do more with less? And so as we're looking at decision-making around COVID, you don't need to, for instance, eliminate positions across the board. You can do it in a way that makes sense for your business. The other thing that's really important to evaluate is whether the layoff is going to be temporary or permanent. And there may be some instances, like the scenario I just described, where you do want to make a permanent staffing cut. And then there may be other times when it's really contemplated, for instance, in a restaurant industry, obviously, that it's going to be a temporary staffing reduction with the intent to recall employees. But one of the things that's really important to remember through all of this is, to the extent that you can communicate the nature and extent of a layoff or a termination to the workforce, it's really important to be upfront about that. You don't want an employee who you have no intent to return to the workplace to be waiting to look for another job. You want to make sure that you free them up to look right away. It's also important that you decide what you're going to do about benefits during this time. Are you going to allow employees to maintain their benefits? Is that possible under your group healthcare plan? Who's going to pay the premiums during this time? Is it going to be the company or the employees? Are you going to issue COBRA notifications? And then the other thing that really should be considered, and a lot of people a lot of companies are implementing across the board or strategic payroll reductions instead of layoffs. And that really does play to the Payroll Protection Act as well, because the loan forgiveness is only available up to $100,000. So some companies are asking their most highly compensated employees to take pay cuts beyond the forgiveness amount. So there are ways to be strategic around that too. And then really, finally, and most importantly, as you are implementing all of these decisions, it is really important to be mindful of all of the other laws that apply to any employment decision-making. Because I always say that for a small business in particular, employment law is a huge risk because there are so many laws that govern the employment relationship. Most of them are not intuitive. And it is, I always say that you really can't stumble your way into compliance with good intentions because some of the laws are so confusing and tricky. And so as we find ourselves in this really difficult, novel situation, it's important that you're contemplating all of the existing laws, including the overtime laws, the FMLA as it existed before and as it's been amended. It's not listed here, but the Americans with Disabilities Act and requests for accommodations, all of the Ohio statutes that correspond with these statutes as well, that have a broader application to even the smallest employers. And finally, the Warren Act that deals with notification of mass layoffs. So I see that my time has about run out, but I am happy to answer any questions that our audience participants may have.
Do you want to just take one quick minute and address our last sort of question, which was when is an employee entitled to paid sick leave?
You know, I would say that there are some new laws that our audience needs to be generally aware of, and that was the first legislative response to the COVID virus was the Families First Coronavirus Response Act, which has two components that relate to sick time. One is the employee sick time, the Emergency Paid Sick Leave Act that gives 10 days paid sick leave to most employees for COVID-related illness. And then the second piece of that is the FMLA Expansion Act, which we could probably do an entirely separate webinar on because it's really quite complex. But the thing that's important for most of our audience members to know, because they're probably thinking, well, I don't have 50 employees, the FMLA doesn't apply to me. This amendment, which is temporary to the FMLA, it's temporary and it's in response to the virus, expands FMLA coverage to employees of smaller employers. So it's important to know that there may be FMLA considerations, at least for the immediate future, that apply to your business that may never have applied before.
Great. Thank you, Henry. I know it's a lot. There's a lot to deal with in the employment relationships in this world with the millions of jobs that are disappearing from the workplace, but it's something that every employer has to deal with. So thanks for those Q&A. I know we have a couple of questions. Maybe we'll get to more of the questions at the end. Next, I want to move on to the banking and finance portion, and we have Mike Makofsky here, who's the lead of our banking and finance group. Mike, maybe we'll start with, I know the Paycheck protection program and economic injury disaster loan programs all through the SBA have gotten lots of publicity. Maybe you want to start and give us just sort of a status update on the Paycheck protection program.
Sure. Thanks, David. The PPP has been ever changing. In fact, I updated this last night and this morning because of events. So I thought it'd make sense just to talk first about where we are right now. So as anyone who's listening has been through this process, I'm sure they can appreciate it. It was a very complicated process. And it seemed like it was more of a speed over process endeavor with people just trying to get applications in as quickly as possible. But as of yesterday, all the PPP funds have been allocated. And that doesn't mean paid out yet, but that means they've all been allotted to approved loans. So at this point, the SBA is not accepting any further applications under the PPP. There have been discussions about another round of financing. I think they said it's $250 billion, which is still being negotiated in Congress, but has not been finalized as of this morning.
So Mike, just on that point, if they're not taking applications, does that mean clients should just ignore it and say it's all gone away? Or if this, should they be ready if the next 250 billion does come through?
Yeah, exactly. I'll touch on that in a second, but just to give the scope for everyone listening, the SBA said that they received more applications in the last 14 days than they've received over the prior 14 years. And so that translated to 1.6 million borrowers. So again, just to give everyone the scope of the applicants for this. So along with the PPP being shut off for now, if folks are familiar with the EIDL, which is the Economic Injury Disasters Loan, which is another SBA program, that has been shut off as well for the time being, just because they don't have any further funding for it. Overall, I would say in talking with our clients, again, it was a complicated process. It was a challenging process. Lenders develop their own processes, their own applications for this. And a lot of the loans were to existing clients. Larger institutions tend to be more deliberate in it. Some weren't even online on the first day, didn't have their portals available. There were some lawsuits that have been filed against some larger banks in terms of their processes. But part of the challenge too is that the SBA continued to revise its guidelines throughout the process. And as companies were trying to do their calculations and file the applications, the guidelines were being revised. So what we're starting to find is that some companies who have received their funds, they've actually received more than what they've requested, and some have received less than requested. And again, a lot of that goes to some of the guidelines have changed in the interim after the applications have been filed. So I would say, to answer David's question, that if a company has not filed, but still needs to or intends to continue to talk with their bank, to have all your paperwork ready, and be ready if and hopefully when there's a new tranche of funds available.
Hey,
Because,
Mike,
yes.
there's a question from one of the participants who's saying that their bank is saying that their loan has been sent to closing for review. Is there I've heard of businesses whose application has been accepted. This person's application is in closing for review. And then I've heard of people whose status is approved. Do you have any sense as to what that means in terms of whether those businesses will get funded through the loan based on that terminology?
So the way I've understood it is it's submitted, and then if it is approved, you are assigned a loan number. And then after that, it goes to it's been designated for closing, and then it will happen within a certain amount of time. So it's in various stages. So some companies have been through it and they have their money already. Some are still in that closing process, but they don't have it yet.
Is that money earmarked by their bank for them?
Right. So if they've been approved and they have the number, my understanding is that money is earmarked for them. So the funds, they have been allocated to them. They're just in the process of receiving them.
So Mike, let's say someone is lucky enough to have gotten their program in and they've gotten approved for the loan. How do they go about deploying the funds of the loan to make sure that they're going to get loan forgiveness if available?
Sure. So, I did see some questions about calculations of FTEs and so on. It's a little bit beyond the scope of what we're talking about right now, but we're happy to have that conversation offline. So if there's a company who has received their funds, the key is the timing on the deployment. The funds must be used within 8 weeks of receipt. Okay. And as Anne-Marie mentioned before, the purpose of this is really to maintain headcount and pay rate for our employees. So, and this sort of goes into the forgiveness aspect as well. 75% of the funds need to be deployed to maintain the employees. So what I recommend or suggest is pay the employees first, and then the other permitted uses, interest, rent, utilities, and things of that sort, to make sure that you're complying with the forgiveness rules. Any unspent funds are not forgiven. So if you have the funds, deploy them. It does not work to just hold on to the money. And lastly, the forgiveness process on June 30th is when companies can apply for forgiveness. None of the forms are available yet, and the process haven't been fully developed. But just keep that in mind, as that's when the process can begin.
So I think part of the takeaway from that is use the money on employees first and document that you spent it towards employees, right? And so that you can submit that to make sure you get forgiveness.
Yeah, and that's a really good point, because we don't know exactly what the requirement is on the forgiveness portion, but it's safe to assume that there is going to be some requirement to document how the funds were used. So keep records of how the funds were deployed.
Great. Now, if apart from the SBA, the PPP, and the EIDL loans, what if my company can't make regular installments on its normal bank loan?
So as we've seen, I mean, the purpose of the PPP loan is really to maintain employees. It's not to pay, your principal on your loan. So if a company is not able to make their installments, the first thing they should do is seek deferment. Some banks are proactively deferring borrower loans, and others are waiting for companies to request it. So if you're in this situation, you have not heard from your lender, reach out to them and talk about your situation and ask for a deferral. From what we've seen so far from our clients, the deferral terms typically are a 90-day period of deferral on principal and interest. After the 90 days, the interest payments usually commence. In terms of the unpaid principal, some have it repaid over a several month period. Others are just added to the principal balance at the end of the loan and have to be paid at the maturity date. The other point I wanted to mention is what I call the COVID-19 covenant. Is what I've seen in these deferment documents is that the lender is requiring the company to represent and warrant that the request is made because of the COVID-19 pandemic, and that they are in an economic hardship, and that the deferment is required. Obviously, they don't want companies taking advantage of the situation, so they're having language to that effect. And then lastly, I have here sort of the right bank relationship. I mean, it's always a good time to be thinking about this, but I think especially now, it makes sense to really think about who your bank partner is, and to make sure that it is a trusted relationship. Even if you don't borrow, I always think it's a good idea to have a relationship with a bank or have a line of credit that you don't tap into. But it's a good time to take stock of your loan agreement provisions, really understand what you're agreeing to do, what your financial covenants are, what the other requirements are. So as an example, there's usually a covenant against additional indebtedness. Well, the PPP loan is probably considered indebtedness under your loan agreement. So if you're not doing the PPP through your current lender, then you're going to need to talk to your lender to make sure that they consent to the loan. So, and then a couple other points is just to be proactive and communicate with your lender. In my experience, banks hate to be the last to know. They'd rather have over communication than not enough communication. And so just, talk to them about the situation. And then the last point is sort of a fairly obvious comment, but cash is king. So if you have lines of credit that you can draw on, consider that, or even talk to your lender if there's ways to speed up receivables, convert to cash quicker, any other ways to maintain liquidity.
Great, thanks, Mike. We had one question I see up there now is do I need to have an existing lending relationship to be a priority for a PPP loan with the bank, or would a business banking relationship be enough if I didn't have any debt from the bank?
So this became a big part of the whole process, where most banks were prioritizing existing clients over non-clients. And part of that has to do with the fact that there are know your customer requirements for banks, and they're heavily regulated. So just because of the time urgency, they were prioritizing existing clients who they'd gone through that entire process with. So it's not to say that if you're not a client, you don't have the opportunity, but you're not going to be prioritized. So what happened most of the time is clients went to the bank that they currently have a loan with or a line of credit. If you don't have a loan, but you have a bank account, I mean, that certainly helps as well. It is really only when those banks weren't giving the attention required that clients sort of went to new banks to try to get some help.
Great. Thanks, Mike. I know we have a whole host of questions up there on the board. We'll try and get to some of them at the end, but maybe we can move on to the real estate section, which is what I will handle. So first sort of question that I've seen a lot from clients is saying, hey, my business leases space. What if I can't make my rent payment? I think there's a number of things you need to consider here. First of all is the sort of legal answer and the laws that are out there, the new ones. There's an executive order from the governor that basically requests commercial landlords to give a 90-day suspension of rent and issue a 90-day moratorium on evictions. Now, it's an executive order, and however, it's advisory. It's not binding law. No one has to abide by it. It's just the governor trying to say, please do this. So it's not binding on landlords, but it's something to point to. There are some pending bills in Ohio legislature. There's a Senate bill and a House bill, both of which try and take those advisory opinions from the governor and turn them into law. There's been no action on those yet, but they're out there pending to see if they can become law. On the local level, both Cuyahoga County Common Pleas Court and the City of Cleveland Municipal Court have current administrative orders in place that effectively prevent eviction hearings from being held until at least the end of May. So you need to consider all of these things when and if you can't make rent payment or you're getting pressure from a landlord on it. Next, you need to sort of consider the contractual remedies. In essence, look at your lease and see what your lease provides. Some key things to think about is force majeure, which is another way of saying sort of an act of God. A lot of leases and other contracts have a force majeure clause that says if there's an act of God that prevents performance, then we'll excuse that performance. So look at your lease and see if it's in there. I will point out, however, that most of those in leases have an exception for payment of rent. So it may not help you in paying rent, but it's certainly something to look at because not every lease is the same. Second, you need to look at landlord obligations. Are there any sort of common area requirements that the landlord has to do? Do they have to maintain areas? Are they not cleaning for the government or CDC recommendations? Or are there other obligations that the landlord should be doing that is not under the current situation? That might give you some leverage with the landlord. Next, are there any early termination rights in your lease? Obviously, if you had an early termination right and you couldn't pay, that'd be an easy way to get out. That's great. But maybe you have an early termination right in a year from now or 2 years from now. you might be able to use that as leverage to talk to your landlord and say, hey, I'll forego that early termination right if I get a deferral of my rent payment or an abatement during this COVID. So give me the 90 days with no rent, and then I'll waive my early termination right next year. That might be a way you can go about it. Next, look at in retail situations. Oftentimes there are co-tenancy or anchor store provisions. So co-tenancy provision is, hey, if a certain percentage of other tenants aren't open, then I get a right to terminate. Or an anchor store provision, if an anchor store like a department store or a Walmart isn't open, I might get to close. Those might be applicable to you if you're in a retail situation. There's legal doctrines of impossibility and impracticability of performance. Those are difficult arguments, but things you may want to look into if you're being pushed by the landlord. Basically saying, I know what the lease says, but given the current situation and the stay-at-home order, it's impossible to perform, so we should be excused from performance. You also need to always look at, when you have a lease, are there any personal guarantees, or because that will substantially change your leverage in negotiations if the landlord knows there's a personal guarantee on there. Last thing to be careful of, and this is both ways, landlords and tenants, is always follow the notice provision. So if you have a problem with your landlord and they're not doing something, make sure you follow the notice requirements of lease, where notice is delivered, how it's delivered. Likewise, if the landlord's going to try and tell you you're not paying rent and evict you, have they given you the proper notices they're supposed to, required by the lease? Because if they don't, then presumably there's not a default until they do give you the right notice. And likewise, there may be some grace periods built in there. Finally, I would say, not finally, but other thing to do, as sort of Mike said, talk to the bank, is call your landlord. Be proactive about it, because you understand that they're in a situation where they probably have a loan and a bank that they have to make payments to, and if they don't get rent payment, they can't make their loan payment. So be upfront with them, talk to them, ask for a deferral, ask for a reduction in rent or an abatement. Try and structure something where you get 90 days rent free, but then you'll pay it back over a period of time, or you'll agree to a lease extension if you get an abatement for a period of time. It's better to have the conversation than surprise the landlord with no rent check on the first of the month. And finally, some of the things we've talked about, any financial remedies, the PPP loans or the EIDL loans. I know Mike mentioned those. Those could be a way. I know some of the proceeds can be used for rent, up to, I think, 25% of the PPP loan can be used for rent and still get forgiveness. So those are a method. Also, insurance. Does your business have business interruption coverage insurance? It's a burgeoning area of the law. Oftentimes, those insurance policies contain a specific exclusion for pandemics, like we're experiencing now. But the law is ever evolving, and there are lots of claims being made on those, including some of the lawyers from our firm are gathering other businesses that have losses and pursuing business interruption coverage for them. On that, one thing I would point out is whether or not you think you have coverage, submit the claim as soon as possible, because you don't want to lose the claim because you gave late notice. So submit the claim, see what you get, and if it's something significant, come talk to us. I know we have some lawyers here that are putting together a whole group of businesses that have these business interruption coverages. The law is also changing on that, because I've seen some of the legislatures are trying to specifically include pandemic in the coverage. I don't know whether that will pass or stand, but the law is changing. So at least submit the claim on time, so you won't lose it just because you've missed out on time. Now, the other thing that I've seen, I've had some clients question is, what if the nature of my business has changed since the outbreak and the stay-at-home order? For example, a lot of restaurants that were sit-down restaurants are now doing takeout only, and things like we've heard in the news, breweries or distilleries are using their equipment to make hand sanitizer. I think those are great uses of way to make sort of lemonade out of lemons. but you need to be careful. Look at the use clause in your lease. Make sure you're not going to violate the use clause in your lease and get into trouble with the landlord while you're trying to do it. Also, make sure you're not going to be violating any zoning and or have any permit issues if you've changed the use. Things to consider. Another issue that I've seen pop up is, say my landlord wants me to shut down, but I want to operate. What are essential businesses? The Ohio Department of Health issued their sort of stay-at-home order on April 2nd, which detailed a whole list of what are essential businesses and what aren't. Those decisions as to what's essential or not are made by the local health departments. And so there have been some situations where, one county determines that the type of business is essential and another county determines it's not. And the governor and lieutenant governor have put together a dispute resolution committee that will resolve those discrepancies and make a determination as to whether your business is essential. Likewise, if your landlord forces you to shut down because they don't want to have anyone operating in their space, look at your lease. I always say go back to your lease. Does it give you any remedies under your lease? Does it give you claims against the landlord for forcing you to shut down? Does it give you rent abatement? Always go back to the lease and see what it's out there. Finally, a similar question to the lease. Say my business owns my building, but I'm having trouble paying my mortgage. What can I do? I think the advice there is very similar. The governor's executive order, which again is advisory, not compulsory, but it requests a 90-day forbearance by lenders if you're not paying. So you can certainly do that. Some banks are, as Mike mentioned, offering deferrals and have offered them up. We talked about the PPP and EIDL loans, and also previously mentioned possibly making insurance claims on your business interruption coverage. But the key thing to think about with whether it's a landlord in a lease situation or a bank in a mortgage situation is communicate and communicate and communicate. Make the call, tell them you're having problems, and you're going to have a better chance of working something out with them if you communicate rather than surprising them at the last minute with that. So I think that ends our sort of Q&A or our FAQs we have, so to speak. Let's see if we have any questions from the audience. Maybe we can take some time to answer those.
David, if I may just tack on to what you were saying about business interruption claims and insurance policies, and to just provide a little more information about what McCarthy Lebit is doing in that regard. We are looking particularly for those businesses who have been ordered shut by the state of Ohio. So that would include businesses that have, for instance, elective surgery centers, dentists, and other healthcare providers who are no longer able to operate by order of the government shutdown, salons, gyms, things along those nature. We're really looking at matters where the business is projecting a $250,000 loss due to the COVID-19 virus and has a commercial liability policy during that same period of time. And we are reviewing those policies on a no-fee basis to determine whether there may be some ability to pursue a claim on behalf of those businesses.
That's great. I noticed we had a question up there. Will the slides be available after the presentation for later reference? Yeah, I'm sure we can find a way to get those to you. We'll certainly make them available. Let's see if we have some other questions up here as I scroll through.
One thing that I wanted to mention that I neglected to mention while you're looking at those questions, David, is that as a result of the amendment to the FMLA, all businesses are required to put up a new poster that describes employee rights And as many of you know, the Department of Labor requires certain posters to be displayed for employees in an area of common use in the workplace so that employees know their rights. There is a new poster that specifically details rights under the Families First Act, and we will have that available on our website. If you go to our website, there on the front page, there's a COVID, if you click through an entire page of COVID resources, and we will put that poster up for participants to use. And you could just print the piece of paper and hang it where you hang your other EEO and DOL posters for employees.
Great. We have a number of questions that sort of got cut off, so I don't have the full question, but Anne Marie, here's one for you. What do you do when an employee is afraid to come back to work with no COVID illness or qualified COVID reasons?
So this is a very good question, and one that we're seeing pretty frequently. You know, there are a number of laws that are implicated by this question. And you know, if the employee is an at-will employee and you are an essential business not subject to closure order, then the general rule would be that you as the employer can tell the employee that they are required to come to work if they are just have a generalized fear about exposure. However, it gets a little murky depending on how it's communicated, what the employee's health situation may be. So for instance, if the employee says something to the effect of, you know, I have severe anxiety and this situation is exacerbating my anxiety. That's something that's very scary for employers, because whether the employer realizes it or not, that employee has in all likelihood made a request for an accommodation under the ADA and the related Ohio statute. So for an employer just to simply say under those circumstances, you have to come back would probably be an ADA violation. Because at that point, the employee, even though they haven't specifically asked for an accommodation, has given the employer enough information to know that an accommodation may be necessary, and that triggers an obligation on the part of the employer to engage in the interactive process of determining whether an accommodation can be made. And if this employee has been working remotely for the last 6 weeks, it's going to be very difficult to argue that working remotely is not a reasonable accommodation of that disability. So what I would say is that if you have an employee who raises these kinds of concerns, this is a situation where I would say you need to get counseling about employment law, because there's a lot of, that's just one statute that comes to mind that's implicated by those kind of concerns being raised.
Great, thanks. Mike, here's one that came in on the PPP that maybe you want to take. Since the Paycheck protection program has been exhausted, is it advisable to apply for a economic injury disaster loan? I've already applied for the PPP, but heard the news PPP is exhausted and haven't had a confirmation from my bank.
Sure. So as I mentioned earlier, you know, unfortunately, the EIDL has been exhausted as well, and the SBA is not taking applications for that at this time. We're hopeful that if there's a new tranche that's been approved, you know, there will be more funds for PPP and perhaps the EIDL. So if, I guess at this point, I would say if you did not get a confirmation from the bank that your application was approved, and you weren't assigned a loan number, there is a chance at this point under the current, under the existing program that you may not be allocated funds. But as we talked about earlier, we would suggest that continue to talk to your bank, get your paperwork ready, you know, work on the calculations and be ready. So, you know, as soon as hopefully there's another tranche available, you can file as quickly as possible. The other thing I would say is if you have already filed, you can't file again for a PPP. So it is really a first come, first serve. So if you're already in the process and more funds come available, there is a chance that you will get your allocation because you're in line, so to speak.
Great. One of the things we want to make a distinction between the PPP loans, which are hopefully entirely forgivable, versus the EIDL loans, which are true loans. But one of the benefits of the EIDL loan is that there's a possibility that just applying for it, you could get a $10,000 grant. Even if you're not applied for the loan, you might be able to get just a $10,000 grant, even if you're turned down for the loan. But I guess until those, I guess the point is they're both shut off for now, but be ready to submit your stuff to your bank and have a banking relationship. So if those do get recalled and refunded, you can get in the queue for those.
Yep.
We just got a question up here. It says, what do you suggest for real estate taxes payable to Cuyahoga County on a business-owned building due in July? It's a very large number and we have zero income. That's a great question. I think it's phenomenal. I haven't seen any specific law on that yet from the county as to allowing you to not pay them. But something we'll look into and we'll post something on, because I think it's a great question. The governments have been very convenient and supportive in delaying payments, and even the governor's executive order, advisory order, telling lenders and everyone else to forego payments for 90 days. I got to imagine that they would do the same for the county, but I haven't seen any specific law on that yet, but we'll look into it. I think it's a great question. Other question, maybe for Anne Marie, is there any protection for employees who are simply afraid to come into, presume it's the office?
I think we covered that one.
Come into work, yeah. Okay, I think that although maybe we didn't get to all the questions because some of them got cut off, we answered a lot of them and we're coming up on the end of our hour. What I'd like to do is say, again, thank you to Cose for having us here and letting us do the webinar. We're proud to be partners in Cose and hope to provide continuing value to all of its members. In addition to this webinar, what we're willing to do is give an exclusive offer to Cose members of a sort of a 30-minute no-fee consultation, where we can give you some of the advice that may be more specifics on some things that we talked about today. On the email invite you got, there's a link to click on to get into a landing page at our firm where you can sign up, ask for some basic information, and one of the firm attorneys will contact you to set up a time to do this consultation. It's something we wanted to do consistent with our motto, expect more, get more. We want to provide value to Cose and to all its memberships. We think we're a good partner as a small business ourselves and look forward to it. So with that, I think we're adjourned, and we haven't gotten to any of your questions you want. Feel free to log in, sign up for one of our 30-minute sessions, and we'll be happy to answer them. So I think up now is the landing page for the consultation. Appreciate it. With that, I'll give it back to Allison for the sign off.
Great. Wonderful. Thank you so much to the team from McCarthy, Lebit, Crystal, Liffman for sharing so much wonderful information and insight with us today. And thanks to all of you for joining us. As we just mentioned, you will be receiving a link for the free consultation in the follow-up email after the webinar. We hope you found today's presentation engaging and informative. And if you have any thoughts to share, please let us know. This concludes today's session. Thanks again.